Allen, Senior Manager of Platform Sales for Focal Point Data Risk, focused on the HIPAA Risk Advisor platform. And I want to welcome you to our webinar today, Everything You Wanted to Know About HIPAA But Didn't Know Who to Ask, brought to you by Focal Point Data Risk. So I'm joined today by Eric Dietrich, a principal with Focal Point's data privacy practice. Eric has a lot of experience with HIPAA compliance projects for organizations both small and large. He's also the KnowledgeNet chairperson for the International Association of Privacy Professionals for the South Florida region. Also joined today by Francesca Sanabria, who's also a principal with Focal Point's data privacy practice. Francesca also has extensive experience developing and implementing privacy programs for multinational organizations, working on compliance efforts for both local and international data privacy laws, including HIPAA, and extensive experience with industry and regulatory compliance, such as HIPAA and HITECH and SOC 2. And finally, we're joined today by Catherine Kim, and Catherine's a manager with Focal Point's data privacy practice. And Catherine also has extensive experience with HIPAA as well as the HITECH Act, Americans with Disabilities Act, and the Affordable Care Act. And prior to joining Focal Point, Catherine was an attorney investigator with the U.S. Department of Health and Human Services, Office of Civil Rights, which is, of course, the enforcement body for HIPAA regulations. So I want to thank all of our experts for joining us today. A brief introduction to Focal Point for those of you not familiar with us. We are a cyber risk management firm headquartered in Tampa, Florida. We do have 13 offices around the country and including Canada. Over 400 professionals throughout North America with expertise in cybersecurity risk management across a variety of industries. So we'll be focused today on healthcare, of course, but we do serve major industries and government as well. And we have a unified approach to our engagement, so we're going to include our experts, specialists in each of our projects we're working with across these different industries. And of course, today we're really focused on our HIPAA expertise, and the data privacy practice I mentioned has been in the business of HIPAA consulting and HIPAA expertise for over 10 years now. Lots of projects with lots of types of organizations, small and large, and have the legal and technology and regulatory background to succeed with our customers. So a quick look at our agenda today. First off, we're going to recap some recent HIPAA enforcement actions and take a look at a quick review of them and what lessons we can learn from them. Then we're going to take a brief look at our HIPAA Risk Advisor platform and a tool for assisting with HIPAA compliance and HIPAA risk assessments. And then really the main purpose today is the Q&A. So we have the panel of experts available to answer your questions about HIPAA, and we hope you brought lots of questions for us. So with that, I'm going to turn it over to Eric to take us through the next few charts.
Thanks, Steve. Welcome everyone who was able to join us this morning. We look forward to your questions in a little bit, but we wanted to start off today's discussion just focusing a little bit in on two recent enforcement actions that were published by the Health and Human Services with OCR. And then the first one we'll talk about here is the Metro Community Provider Network, or referred to as MCPN. And they provide a variety of healthcare services to individuals in the Denver metropolitan area. So they're a quite large organization providing those services. So back in it was January of 2012, they had an incident that was some type of phishing attack that ended up exposing approximately 3,200 individuals EPHI, and through further investigation, the OCR identified that a risk analysis, the first one that they had available, was performed in February of 2012. So you can see what happened here was the individuals realized that they had a reportable event. They followed the protocol. They reported that to OCR as required, especially on a timely level since it was greater than 500 individuals exposed. And then OCR, as they often do, opened up an investigation to gather further details about the potential incident, started to gather and request for certain information, and usually something that's always requested, it would be the risk analysis that was performed to identify the potential threats and vulnerabilities to that EPHI for the specific organization. And when they requested that, they realized it was done post this incident. So that ended up leading to a settlement of approximately $400,000, and they entered into a corrective action plan. Now, for those that aren't too familiar with these corrective action plans, these are basically agreements that are made between the organization and the regulatory body in certain activities that need to be performed in subsequent years. So usually it's made up of certain activities that need to be performed or enhanced. So in this case, they required them to, one, conduct a risk analysis again and provide that report back to the specific OCR representatives. They required them to update their policies and procedures and provide that back to the regulators, update training, and a few other procedural level activities that they need to be performed. And the interesting thing here is not only do you have to deal with the $400,000 settlement, but then you have to, I believe this one was for a period of 3 years, continually provide updates on your overall risk management program and the specific activities that you've agreed to in the corrective action plan. Not somewhere we want to be. But if we go on to the next slide, we'll see that the activities here and just kind of some of the results on this investigation realized that, you know, the MCPN took the necessary steps to mitigate that phishing attack. It appeared that they retrained some individuals to make sure they didn't click on those links. But it really came down to the lack of not performing a risk analysis and understanding what those threats and vulnerabilities might be to that EPHI and taking the appropriate measures to align with the security rule. So what can we learn from this specific incident is, you know, let's not wait to perform a HIPAA risk analysis until something, a breach happens or some investigation happens, and the importance of doing it thoroughly and correct the first time and getting either guidance or advice from various subject matter experts out there. So it kind of summarizes the NCPN review that we wanted to talk a little bit about and highlight some of those key activities. Now, if we go into the next one,
sorry, Eric, you're cutting out a bit. Hopefully it's not just mine. Go ahead, try again.
Sure thing. I just wanted to reiterate that these were recently published, so these are all relevant. They were all released by OCR in April of 2012. So while these events might have been triggered back a few years ago, you can see the length of time that these investigations take place, often the negotiations that have to take place, the settlement agreements, and so forth. So a lot of these happened 3, 4, 5 years ago, but these are all recent items that can be viewed on the hhs.gov website, where they provide further details into all these corrective action plans. And here at Focal Point, this is something we regularly do as new corrective action plans and enforcement actions are issued. We'll review them and look for certain trends, especially in the what they're asking these organizations to do. So now we'll jump into the second one we'll talk about today, which is CardioNet. So CardioNet is a organization that provides technology to help monitor cardiac activity. So heart rate monitors, things like that, all different types. And a lot of them are mobile in nature. A lot of them do it at home for telemedicine type of purposes. So this one was also interesting, and with a much higher fine associated with this one. So this one ended up being a $2.5 million settlement that took place. And once again, it was a few years ago that CardioNet reported to OCR as required of an incident taking place that a workforce member's laptop was stolen from a vehicle parked outside their home. Still a very common occurrence and a very challenging thing to prevent unless you have good training and you have some strong controls in place for those mobile type of devices. So in this one, there was about 1,391 individuals' records that were exposed, and they lost that. It was unencrypted at the time, but similar to the prior breach and enforcement action, OCR did an investigation, followed up, and realized that there was an insufficient risk analysis performed. There wasn't detailed risk management program in place, and then further, they realized that a lot of the policies and procedures that were drafted were in draft state and never publicized to the remaining workforce members. So something we see quite often, there can be great efforts done by the immediate project teams. The policy and procedures are created, drafted, but then often get hung up in that approval process within an organization and maybe not officially rolled out. So making every workforce member aware of where these policies are and making sure that they're communicated out there. And then this one also had a little bit of a mobile spin, mobile device type of security. So once again, this one was a settlement that was much larger than the first one, and that it was $2.5 million and a corrective action plan. And while the corrective action plan for this one has very similar requirements of the organization to perform for the next 2 to 3 years, including conducting the risk analysis, implementing a risk management plan, the training, making sure those policies and procedures are updated. This one created an interesting element as well, where they are required to implement encryption for all mobile devices. So this included laptops, flash drives, memory cards, and other mobile devices that CardioNet might have within their infrastructure. So as we all might know, encryption technically is an addressable requirement within the HIPAA security rule, meaning that you could justify you need to justify the use of it, and really, if you're not going to encrypt something, that there is a rationale why there is an encryption. However, over the last few years, we continue to see that encryption is more of a technically more of a requirement, and except those very rare cases where the cost or the technical implications outweigh your ability to do such. But as we continue to see, the tolerance of OCR for things not being encrypted continues to really elevate up. And there's very few cases we see these days except for legacy type of enterprise applications that don't have the ability for encryption. That especially mobile devices, the expectation is that there is some level of encryption being done for when EPHI is being stored or processed on those devices. So those are some of the activities, as well as coming back to the main theme is that this idea that if you don't do a risk analysis, it's very hard for an organization to demonstrate that you know where those risks are and that you have those proper controls and safeguards in place to mitigate those risks, and then also have the supporting documentation to ensure your workforce members continually follow those procedures that have been designed to mitigate those risks, and then further, always making sure that there's that training in place to make them aware of the policies and procedures, which then dictate those procedures, which help reduce those chances of this potential breach from having. So hopefully, and if you go on to the next slide here, we'll just kind of recap those activities that we talked about. Is really that protection of that EPHI starts with that risk analysis. So you understand where those gaps are and how to mitigate those, and ultimately ensure alignment with the various HIPAA requirements that might be applicable for your organization. And then the continuous implementation of those various elements that make up an overall HIPAA compliance program, which often starts with the foundation of those policies and procedures. And making sure that they're made and distributed to all the workforce members for what they're relevant, making sure they're readily accessible, and that they're in a published kind of approved state and not remaining in that draft state. So all those elements really help, in the event that something happens. And as we know, the days that we live in now, an event is going to happen. So how do we ensure that it is minimal impactful to the organization, to our patients, to our customers, and that we're mitigating that to the best that we can, and really making sure that that risk analysis is that foundation for which drives our overall HIPAA compliance postures is key. So that really covers off on those. So just to summarize, and I think I've already covered off on some of these, is that, either the risk analysis, the lack of doing one, the incomplete risk analysis, or one that's not aligned with the guidance that's been issued by OCR over the last couple of years, really prohibits the inability to create that strong risk management process. And then what is requested of an organization, whether it's a covered entity or business associate, after a security incident has occurred, especially a reportable incident that has occurred, there's a very high likelihood that the risk analysis will be asked for within the evidence that is being collected by the investigator. So making sure that that is complete, readily available, up to date, periodically refreshed is a very important thing. So now I will pass it back on to Steve to talk a little bit about the HIPAA Risk Advisor platform, and then we'll have plenty of time to open it up to questions.
Thank you, Eric. So as we just talked about, there's really at a high level 3 elements for HIPAA compliance. There's having documented security policies and procedures, having some training in place for employees, for your workforce, and doing regular risk assessments, risk analysis. And our HIPAA Risk Advisor platform addresses all 3 of these areas. Today we're going to focus on our risk assessment process, but the platform itself does provide templates for developing policies, procedures, and training for your employees. So with respect to the risk assessments, we have a streamlined 5-step process for conducting a risk analysis. And it starts with an online questionnaire that a practice, or in the case of a business associate, an office manager, is going to complete. That can typically take a couple hours. It's a set of questions that address across the administrative, physical, and technical safeguards. But it's all done online, remotely. And when that questionnaire is complete, that's submitted for review from our experts, some of them who are on the line today from our data privacy practice. But HIPAA experts that can review this and then conduct an interview with the practice administrator, the office manager, who's ever submitted it on the customer side. And you really step through the responses, clarify any responses, and address any open questions that maybe have not been addressed. Then our experts are going to do some analysis and prepare a gap analysis report with detailed recommendations, and ultimately review that with the client. So what's key here is that it's a streamlined process, it's online, but it's not just an online tool. We're combining that with remote HIPAA expert consultants as part of the solution. So I'm going to walk through each of these steps in a bit more detail, but we're not going to do an online demonstration or live demonstration today. We would be happy to do that for you if you'd like to see that at some time after the webinar. So again, the step one is that self-analysis, the online questionnaire, and very simple, intuitive interface. It's going to cover the technical, physical, and administrative safeguards, but not just asking yes/no questions, but also providing you the opportunity to upload supporting documentation. And as you're doing that, going through the questionnaire, you ultimately build up a little mini repository of things like your policies and procedures documents, could be a system diagram from a network layout, and the types of information that you would need to have readily available in the event that OCR did call on you or that you were subject to some kind of an audit or inquiry. And again, if you have your information readily available, this process can be as short as 90 minutes to a couple hours. So from there, once you submit the questionnaire, that's going to come to Focal Point. We're going to review your responses, the supporting documentation, the policies and procedures that you would have submitted, and schedule an interview with you to prepare to discuss what you've submitted. So in that interview, again, we're going to go through were there questions that were incomplete or you weren't sure how to answer. If we notice that you said you weren't really doing something, but you actually are meeting that requirement in a different way, we're going to make adjustments to how the risk scoring is done. So really that live interview is an opportunity for our experts to get a real good sense of what you're submitted and what your position with respect to HIPAA compliance is. So then we will go off and take 3 to 5 days to prepare this report, and it's a gap analysis report, but it's not just telling you that there's gaps, but it's going to address what the severity level is for things that are open issues, and the real value is the very specific set of recommendations to remediate open issues and address those gaps. So I pulled from a sample report some of the types of things that are in that final analysis. So we do generate this dynamic risk score, which is based on how the responses to the questions are being answered. And in the top right, you see we look at across all the HIPAA safeguards to what extent you're completely addressing the requirements per the regulation and specifications. And that's useful, of course, but I think what may be more useful is really understanding what the severity levels are for the things that are not fully addressed. So in this case, they had 52% not addressed, but maybe a lot of those are lower priority things where documentation might not be right versus a higher severity item might be not having antivirus software running on all systems in the practice. And then on the bottom right, you can see a small example of kind of recommendation. So we're going to spell out specifically, here was the requirement, here's what we found, here's what you're doing or not doing, and then here's the recommendation of what needs to be done to be more compliant and ultimately more secure and less prone to a breach or an attack. And of course, finally, we're going to review that report with you. So again, it's another time to have that interaction with our experts, and we're going to step you through this report, kind of the last process, and then from there you'd be prepared to have a plan to remediate open gaps or understand what needs to be done to move forward. And again, happy to take anyone through a complete demonstration. There's a link at the end of the presentation where you can sign up for a demo, and we're happy to do that. Or if you have questions on the HIPAA Risk Advisor platform, feel free to ask those during the Q&A as well. Speaking of which, we are at the Q&A time, and you can ask a question using the GoToWebinar tool. So I will give a few seconds for questions to come in. In the meantime, I have one here, so I'll ask our panel to kick us off. So with respect to organizations that you've worked with that are doing HIPAA security risk assessments, what are some of the mistakes or common issues you're seeing organizations make when they do a risk assessment?
Yes, hi, it's Francesca. I'll take that one.
Thank you.
All right, so I would say some of the tricky pitfalls, and let's begin with the topic of scope, right? So a key aspect of your risk analysis is to make sure that the risk analysis reflects the scope of the systems and applications that have EPHI or that access to or process EPHI, but also the supporting infrastructure under it. So many times when OCR has gone to investigations, they have given comments and saying that it was insufficient because they were only covering on the applications itself at the application layer, but not really enough coverage around the supporting infrastructure. And what I mean by that is the database layers, the operating system layers, and also coverage around your third parties. So it's very important that whenever we are reflecting and preparing documentation around the risk analysis, that you can have a clear linkage and demonstration that you have defined your systems in scope, and you have defined that all the risk analysis covers in all the systems, and the threats that you are considering to your environment covers that environment. So and it could be as simple as, if you're doing that in Excel, have an extra tab where you have the list of your systems, your supporting infrastructure, and make sure that all the policies and procedures that you're referring to as part of mitigating those threats you can demonstrate that they are actually support all those systems and support infrastructure in scope for HIPAA. So that's one of the first aspects. Second, I would say would be, we see some comments from the OCR on as it relates to that people are pretty good at identifying threats. So threat is what could go wrong, but sometimes they're confusing that to the concept of vulnerabilities. So HIPAA requires organizations to define vulnerabilities and threats, and some companies and organizations are making a mistake of just confusing those terms, and vulnerabilities at the end are what gaps you can have in your environment that are increasing the likelihood and the impact of that threat. So it's very important to being able to tell your thought process and the story that you identify what could go wrong, what's the likelihood and impact of that happening, because I know that I have these known vulnerabilities in my environment. And then you can think about controls and things that you have in place to mitigate that. So separating those two concepts is key. And third, many times we're seeing that the OCR is not only asking for your last risk analysis, it's asking for the last 3 years, for example. So you want to make sure that when you're going through your risk analysis on a yearly basis, you're able to tell a story that you're able to demonstrate that you have been working on remediating those vulnerabilities that you had identified as part of your risk analysis. So showing progress in risk management plans and so forth. So it's very important that as you go to risk analysis, you compare to what your results were the year before, and as again, they're going to be able to see the last 3 years at least. So it's important that you're able to demonstrate that you're doing your due diligence and you have remediation plans for those known vulnerabilities.
Okay, great. Thank you. So our next one is, and I've heard this many times before, our key systems are outsourced and hosted in the cloud. Do we still need to perform a HIPAA security risk assessment? And I know a lot of cloud providers now advertise a kind of HIPAA compliant cloud. So does that get us away from needing a risk assessment?
Steve, this is Eric. I'll take this one for you. So yeah, this is a common question that we often receive, and the answer is no. It doesn't get you out of performing that HIPAA security risk assessment for a few reasons. One is even if your systems are hosted in the cloud, depending on how you have your environment designed and configured, there still might be certain elements for which that EPHI is transferring or being stored. So often an example that we see is, especially for smaller mid-sized organizations, maybe their EHR, EMR is a cloud service provider and it's hosted up in that cloud. But then there might be the local network, local infrastructure components, local file shares, workstations, laptops, tablets, and so forth, all of which, as Francesca was mentioning earlier, are very important to consider when we're thinking about the scope of the overall environment that needs to be evaluated from a HIPAA compliance standpoint. So this is something that, while it helps often reduce the complexity on certain safeguards that need to be implemented, there's still elements that need to be evaluated from from performing that HIPAA security risk assessment to understand where those additional threats and vulnerabilities might lie within within our network and infrastructure there as well. And then there's also the element of just because you outsource it doesn't mean you're outsourcing all that liability as well. There is a certain amount of due diligence that needs to be done by the organization before engaging those partners or those cloud service providers, making sure the contractual language is reflective of that relationship, making sure that they're going to maintain. A lot of times it's assumed that every service provider is doing the right thing, which a large majority are, but then there's some others that, depending on how the language is in that contract, there might be certain obligations for you to manage in order for them to maintain HIPAA compliance. So a common example of this would be using a cloud service provider, but the user access controls and the administration of who could gain access to what functionality, what data within that system often falls back on yourself. So that user access controls, the maintenance of that, having unauthorized or terminated employees having access to that environment, all those threats and vulnerabilities fall back within your realm and need to be evaluated through that risk analysis process.
Okay, great. Thank you. So next question that's come in, you mentioned encryption is addressable but often considered a requirement for mobile devices. What about data at rest? For example, servers storing data to be used in-house within a secure building.
Yes, it's Francesca. So it's definitely an addressable requirement across all your supporting infrastructure that holds EPHI. So if you definitely have servers that are storing data to be used in-house, and even though you might argue that they are within a secure building, which is a physical security safeguards, we also need to think about the threats around logical access. So it's still an addressable requirement overall. But as we have seen, even in the example that Eric was alluding, and I know that one just alluded to a laptop not being encrypted, and it's easier to lose a laptop than lose a server, that we need to think about the threats around attacks on that server, and if they can access the data within it, and then the encryption would have prevented that even more. So, so we see companies and focusing on their higher risk systems where they will have a higher number of records and looking for ways to encrypt those databases, as it's hard for them to justify that all the other controls will give you the rationale not to do it, even though they might be strong, and it's just because the likelihood of those threats that are outside of our control, which are many times, it just keeps increasing.
Yeah, and just to add on to that, to further to just add one additional point for those areas that you might determine internally that, you know, hey, we have many layers of safeguards in place. We are comfortable that the risk isn't elevating up to a level that we feel will, you know, or warrant the spending to encrypt that data at rest on a server. That we do find that there needs to be a documented justification on why that decision was made and what mitigating safeguards are in place to protect or minimize the potential exposure of that data. So as we've been talking about, encryption is becoming more of a de facto requirement, even though it's technically not updated like that within the standard. So for those we think kind of rare cases where encryption is not going to be implemented for data at rest, that there needs to be that documented justification on the additional safeguards that are in place.
Okay, thank you both. Next question is it required to perform a HIPAA security risk assessment on a yearly basis?
Yeah, I'll take that since that goes around the first question that we touched on. So the rule specifically does not formally say that it has to be done on a yearly basis. However, on a practical matter and from a best practices, and only just by seeing what the type of request that OCR is asking whenever there are investigations, it's very hard to justify that you are going to do that less frequently than every year. So, so again, it's not a formal requirement, but from what we have seen, and it's impossible to not justify that. So, and we highly recommend and encourage that on a yearly basis, as I mentioned before, that performed and that you are comparing year to year.
Okay, great, thanks. So this next one, I think we addressed a little bit one of the examples, but if we do have a reportable breach, what kind of investigation can you expect? What kind of documentation would they ask for in the investigation?
Hi, Steve. I'll take it. This is Catherine. So typically what we've seen from our clients is that breaches generally occur due to internal workforce members more often than not than external factors such as, you know, hacker attacks and whatnot. Depending on the number of individuals that are affected, there is a timing requirement that OCR does distinguish. For breaches that are more than 500, that affect more than 500 individuals, the covered entity is required to notify the Secretary without unreasonable delay, no later than 60 calendar days from discovery of the breach. If it's affecting less than 500 individuals, then the covered entity has to notify the Secretary within 60 days of the end of the calendar year in which the breach was discovered. But that's not to say that the covered entity has to wait until the end of the year. They can actually report it at any time during that year that they discover that breach. And I think something that's great is that OCR has kind of revamped their whole breach notification portal on their website. So they've made it really easy for covered entities and business associates to notify the Secretary of any breach that has occurred that they become aware of. And they make it a very easy step-by-step portal so that everyone knows, you know, what documents they need to provide, the details that they need to include, and then a OCR investigator will be in touch with that covered entity or business associate, in which, you know, they'll typically ask for a lot of evidentiary documentation. You know, these are generally policies and procedures around their security safeguard aspects. You know, these are things like user access reviews and audit logs, incident response plans, breach notification policies and procedures, asset management policies, everything that they have in place to show that, you know, they did their best to stay compliant with HIPAA, but, you know, there was some sort of incident or breach that occurred, and what steps they took to mitigate that risk, right? So those are the types of policies and documentation that they would ask for during an investigation. And then typically, if it leads to some sort of corrective action plan, that the investigator then launches, then OCR will follow through with that and follow up with the covered entity or business associate throughout the year, just to make sure that an event such as the breach or the incident that occurred doesn't occur again.
And it's Francesca. I just wanted to add also that depending on what the root cause of the issue was, if in the Catherine's example, she was explaining that it could be due to an internal workforce members, just making a mistake. And if one of the evidence that they may ask if when we reported that to the OCR in this organization is saying that they had to retrain the person, they have a big focus on training. So making sure that we have, the organization has documentation around that HR communication with the person, that training record of that person in particular. So all those training records are super important. They want to make sure that what we did from a corrective action internally, even before you get to a corrective action plan, how we are able to kind of remediate and prevent that from happening again. And if we need to not only train that person, but train other people in that similar job function that could be in that situation. And they will want to see those records as well.
Okay, great. I want to remind everyone, if you want to ask a question, you can do so in the GoToWebinar panel and their questions. We've got a few more in the queue here. So next is an application developer that creates a platform for patients to access health data about themselves considered a business associate?
This is Catherine. I'll take that one. So the short answer is yes. An app developer that creates a product designed to provide, a platform for patients to access their health information, or if they are provided health information about themselves, that app developer could be considered a business associate of an associated healthcare provider. So in that case, the app developer would be subject to HIPAA and its regulations and the ways in which it limits how PHI can be used and disclosed. And so there are a number of, common decision tree questions that you could ask if you are an application developer, or, in turn, if you're a covered entity or a business associate looking to kind of partner up with a developer to create an app. We see that, in today's world, there's a lot of healthcare apps that are out on the market, and it's not always clear whether they're subject to HIPAA, and oftentimes the developers themselves don't even know if they're subject to HIPAA. So a common question, at least to start with, is usually asking, is the covered entity, such as a healthcare provider or a health plan, are they creating, receiving, or maintaining any PHI in connection with the app? And if so, then the developer could be considered a business associate. Another question would be, is the app being used by a business associate of other covered entities? If the app, it does involve some PHI, then the developer is more likely considered a subcontractor to a business associate. I know that's a little bit confusing because it goes a little bit further downstream in the covered entity and business associate relationship. But these are definitely things that CEs and BAs should be taking into consideration. The final question there is really, understanding if the developer is gathering any data from a customer or a consumer. The difference there is that, if it's a consumer-facing app that's not made available on behalf of a covered entity or a business associate, then it wouldn't necessarily be subject to HIPAA, but it could be subject to other laws such as the FTC or other state privacy and security laws. But if it's for a customer, so if it's for a doctor or a health plan or a hospital, then the app is gathering some PHI on behalf of that covered entity and is providing that data to patients or I guess consumers, then the developer in that case would be subject to HIPAA. So it certainly kind of creates a gray area, and I think the best advice there is really to seek, experienced counsel that has experience not only with HIPAA but also experience with the technology field, really understanding that relationship between the developer, the purpose of the app, and its relationship to the potential covered entity or business associate.
Okay, thanks, Catherine. You just touched on this a little bit, but maybe you can, the next question was, do business associates need to follow the same rules, the HIPAA rules, as covered entities? And maybe just briefly, for those not familiar, you could explain the difference when we say business associate versus a covered entity.
Yeah, absolutely. So covered entities are, any healthcare provider, health plan, or healthcare clearinghouse that is creating, maintaining, transmitting, receiving any sort of protected health information, right? Protected health information is any identifiable information of an individual as it relates to their health information. So a business associate is one, it could be any person or entity that is acting on behalf of a covered entity and processes that PHI with the services that they're providing to the covered entity. So a common example of a business associate could be a claims processing firm. They're receiving that PHI on behalf of a covered entity such as a hospital and dealing with that and processing that information and then sending it back to the covered entity. In terms of the rules that they have to follow, for the most part, it's the same. They are not subject to all of the exact same rules as a covered entity. But I think the biggest ones to highlight are, they are subject to, making sure that they are allowing permissible uses and disclosures. They have breach notification rules that they have to follow, not only to the covered entity, but to the Secretary of HHS as well. They also have to comply with individual access rights. They also have to make sure that they provide an accounting of disclosures, and then a lot of the security aspects of the HIPAA rule as well, making sure that they're adequately safeguarding their information on behalf of the covered entity. And I think this kind of touches upon some liabilities that a business associate may have as well. So a business associate does have some liabilities, as I just mentioned, under HIPAA, but they do have some other contractual liabilities as well, and this is mainly because a business associate, and not to get too legal here, but a business associate would be considered an agent of a covered entity under federal common law. And so this means that even if there's no business associate agreement in place between a business associate and a covered entity, a BA could still be held on the hook for some contractual obligations as well. So they could be, subject to not just HIPAA civil money penalties or criminal penalties, but they could also be subject to contractual liabilities, depending on what was laid out in that contract between the covered entity and the business associate. And I think that's about it that I have there. I didn't want to get too legal, so.
We appreciate that, I think. Okay, great. That's all of the questions we have in the queue. I'll do one last call if anyone wants to enter one into the GoToWebinar. And while we're doing that, again, I want to thank everyone for joining or for listening on the replay. If you do want to see a deeper dive of the HIPAA Risk Advisor platform, again, I'd encourage you to go to the Focal Point website, and there's a simple form to fill out, and we'll get in touch with you and get that scheduled. I'm not seeing any other questions at the moment, so again, I want to thank our panel of experts, Eric, Francesca, and Catherine, and want to thank everyone else for joining again, and hope you have learned something, and hope you have an excellent day.